record in case number CVCV081957. This matter is captioned as Republican National Committee et al. Versus Travis Weipert, Auditor for Johnson County. The plaintiffs appear through Attorney Alan Ostergren. Is Mr. Weipert here? Is that you, sir?
Yes, Your Honor.
All right. Good afternoon, sir.
Thank you.
Mr. Weipert appears personally, along with his attorneys. We have Jason Palmer, correct?
Yes, Your Honor. And
then Susan Nearing. Were you expecting Ms. Zimmerman today, or? Oh, she's back there. Oh, I'm sorry. And Ms. Linus is here too. So, all right. We are here on the plaintiff's motion for a temporary injunction that was filed on August 10th of this year. I'm going to go through the pleadings that I have that reference, that I believe reference this motion, and then we'll make sure that we're all on the same page and go from there. So I have the original motion that was filed August 10th, and I have the brief in support of that motion, also filed August 10th. I have the defendant's resistance to both the original petition and to the injunction request that was filed September 3rd. I have defendant's memorandum of authorities in resistance to the plaintiff's application that was also filed September 3rd. I have the plaintiff's reply to the resistance that was filed on September 8th. And then finally, I have the defendant's supplemental resistance that was filed on September 9th. In addition to these pleadings, I have various attachments that were included with these pleadings. Mr. Ostergren, I'll ask you first. One, do you agree with the court's summary of what brings us here today?
I do, Your Honor. May I remove the mask one seat?
Yeah, go ahead and have a seat. Let me address that real quickly. The defendant's side here is a little bit more clustered, but we've got plenty of space between Mr. Ostergren and the rest of the folks in the courtroom and the defense folks. I'm going to leave it up to you all. You can leave your masks on. You can take them off. As long as you're seated. If you get up to move, you need to put them on. That applies to you folks. The court obviously has an interest in making sure I can hear everybody clearly. The same rules apply to me. My mask is off now, but will be put on before we move. So thanks for bringing that up, Mr. Ostergren. All right, now, do you agree with my summary, what brings us here today?
I do. Do you want me to remain seated when I'm...
You can stay seated, that's fine.
Okay, I wasn't sure if that's what was included in that.
And you can stand up without a mask on. It just, you start to move around, that's when we got a problem. Okay. So.
I agree with the summary procedurally and what's been filed, Your Honor.
All right, thank you. And who's doing the talking over here for me? Ms. Nearing?
That will be me.
All right, do you agree with the court's summary, what brings us here today, and my recitation of the pleadings?
Yes, Your Honor, I agree with your recitation of the pleadings.
All right. Okay, before we get into any argument, other than the attachments that you've included with your various pleadings, Mr. Ostergren, do you intend to present any evidence today? And entertain argument from both sides. As part of your argument, you can obviously tell me anything you want me to know. Ms. Nearing, I know specifically, I believe it was in your last pleading, you have some issues with some attachments or enclosures. You want to bring that up as part of your argument. I understand that as well. You can reference whatever you'd like. I have access to that. If I have questions, I will let you know. Mr. Ostergren, I'm going to start with you, sir. Go ahead and make any argument in support of your motion that you'd like.
Thank you, Your Honor. Obviously, we have briefed the issues in this case very thoroughly, and certainly if Your Honor has any questions, I don't want to read my brief to you. And if you have any questions, I'd be happy to address those. I have a few comments on it was labeled a supplemental resistance this morning. I think it's really more of a sir reply. But would you like me to address those now or at in response to counsel's argument?
I anticipate going back and forth at least a couple times, so you can bring up anything you want now, and then I'll give you a chance as well to respond to anything that the defendant puts forward, and we'll make sure everyone exhausts their opportunity to tell me whatever they want me to know.
Thank you, Your Honor. So there's an argument presented by the auditor that the Legislative Council's statutory powers, which are in Chapter 2, do not include the promulgation or approval of an emergency election directive. Our argument in response to that would be to point out that the statute at issue here, the amendment to Iowa Code Section 47.12A, which was contained in House File 2486, and that complete citation is in our brief, that specifically grants authority to the Legislative Council to do exactly what it did in terms of approving the emergency election directive. So that specific grant of power to the Legislative Council surely is sufficient, and it's not relevant that it's found in Chapter 47 versus it's not found in Chapter 2, which generally describes what the Legislative Council does. On the question of home rule, the auditor has not cited any case from the Iowa Supreme Court or Court of Appeals where an individual county officer has been found to exercise home rule authority. The cases uniformly speak of the power of the county as a whole to legislate on local matters. And of course, the county legislates through ordinances passed by its Board of Supervisors. The auditor's duties do not, of course, include promulgating ordinances of a general nature, such as would be passed by a Board of Supervisors. So again, we assert that home rule is no basis to uphold the auditor's actions here. On the standing question, the case of Board of Supervisors versus Lynn County, which is cited in both parties' filings, I would say reserves the question of whether a local official would have standing to assert a question of major public importance. That question is resolved by In re AW, a later case, a much more recent case, which clearly finds that a county attorney lacks the authority to raise the constitutionality, in that instance, of the Indian Child Welfare Act, the Iowa version of the Indian Child Welfare Act. If we compare the duties of a county attorney and the duties of a county auditor, the Board of Supervisors of Lynn County case focuses in on the distinction of ministerial acts by the local official. If you compare the discretion that a county auditor has in administering an election and a county attorney would have in prosecuting criminal cases or prosecuting juvenile delinquency or dependency cases, I think we would all agree that the county attorney has much greater discretion in his or her discharge of the office. But the court still found that a county attorney there could not raise or question the constitutionality of a statute in that case that he was bound to enforce. So the fact that it's a situation where the county attorney is literally representing the state of Iowa, I don't think really answers the question or distinguishes the case in the way that the auditor offers here. The issue is a local county official derives his or her power from the legislature and cannot question the terms under which the legislature has given him or her that power. We have, and Your Honor cited a concern raised by counsel about the decisions that Your Honor made in the Lynn County litigation and that your colleague made in the Woodbury County litigation. Those are persuasive authority. They're not binding on you today, but both decisions were cited by our brief that we filed, and since they are not otherwise published, we believe it's appropriate to make them part of the record in this case so that they would be available in this file for your consideration, and if there is appellate review, that it is part of the appellate record in this case. So far, there has not been an appeal filed by the Lynn County Auditor, nor has there been one filed by the Woodbury County Auditor in response to the relief that was granted in those two courts. Other than that, Your Honor, I believe we've...
At this point, thank
All
you.
right, thank you.
All right. Ms. Nearing, go ahead.
Thank you, Your Honor. We are appearing today on behalf of our client, Travis Weipert, Auditor of Johnson County. I want to begin by addressing the court's question about the record regarding the prior rulings. The supplemental resistance today was filed in order to draw attention to the fact that we are asking the court to keep an open mind in hearing this matter. We are very mindful of the fact that Your Honor has previously decided a similar case in Lynn County. And we ask that before rendering your final decision in this matter, that you do consider all the written filings and the argument today and take the individual facts of this case as well as the affirmative defenses and claims raised in our arguments that are different and distinct from the issues that were raised in the Lynn County action.
And to respond to that, I can guarantee that there are some different issues that are raised in this case that were not raised in the Lynn County case. Essentially, the underlying facts are essentially the same, although there's some differences there too. But this, if there's any doubt, this is a brand new independent hearing, and I'm basing it on the evidence in this case and the law and arguments you're making here today. So you don't have to guess on that part.
Thank you, Your Honor.
And I will also say for the record, for those who don't know, Lynn and Johnson counties are in the same district. And it was the chief who decided that I come down and do this one because of my familiarity with the underlying issues and some of the governing law. Both parties, I think, at one point in time asked to have these cases joined, and at least one party asked to have the same judge assigned. So there's nothing magical or bizarre that I showed up down here because it's otherwise part of the duty. So just in case there was any question about that. But go ahead.
Thank you. As Auditor of Johnson County, Travis Weipert is also the County Election Commissioner, and he is vested with the authority to conduct elections in Johnson County. When he took office in that position, he took an oath to uphold the United States Constitution and the Constitution of Iowa. Those are some weighty responsibilities, particularly in the area of election law. The integrity of the election process is really the backbone of our entire democratic system, and I believe that Auditor Weipert takes that responsibility very seriously. At the conclusion of all the, at the review of all the actions that took place here, we asked the court to find that Auditor Weipert acted lawfully and reasonably within the scope of the law that he was presented with in making a decision to proceed in the manner he did in sending out absentee ballot requests with some of the information pre-populated on those forms. Having acted lawfully and within the scope of his authority, Auditor Weipert had to make the decision to do something somewhat unusual in unusual times. At no time was he motivated in any way by thumbing his nose at the authority of the state. He was at all times working to try to be faithful to that oath that he took and to make sure that the integrity of the election system and the Constitution of Iowa was upheld. In Johnson County, absentee ballot, the use of an absentee ballot is not a new phenomenon. Obviously, by statute, voters in Iowa are allowed to request to vote by absentee ballot. They do not have to provide any reason for wanting to do so. In Johnson County, in the last 5 general elections, nearly 50% of the ballots have been by absentee. So this is not a new phenomenon that the auditor's office has to get up to speed on. They have a whole host of procedures that have been in place to respect the laws in Iowa regarding absentee ballot requests, and then the follow-through of the election process regarding ballots that are provided in that context. And in his actions as auditor, I believe Auditor Weipert has strived to continually improve that process in order to protect the integrity of the system. This spring, there was an unprecedented percentage of votes that were cast in the primary, and there was no indication that any voter fraud took place, and there was no indication that all of those systems that Auditor Weipert put in place had failed in any way or had any glitches or performance issues that would have jeopardized the integrity of that primary election. This spring has brought a lot of unprecedented challenges for all of us who are in various different governmental capacities. Many of the primary elections were scheduled to take place during times when the governor's restrictions on public gatherings were still in place. The Iowa State Legislature actually adjourned for nearly 2 months and then returned for approximately 2 weeks, and all of the remaining affairs that were going to be conducted in this legislative session were concluded in a very compressed window of time. During that very compressed window of time, when there were so many pressing issues that were being addressed, there were 2 pieces of legislation that were passed that affected existing statutes that govern the matters that we are here to discuss today. One of those pieces of legislation was House File 2486. And House File 2486 addressed a number of issues, but of relevance to the matter here, it made some changes to Iowa Code Section 47.1, which has a number of subsections, and this would have been particularly subsection 2 of Iowa Code 47.1. In addition, House File 2643 was passed in a fairly large omnibus bill that contained a large assortment of appropriations and other miscellaneous issues that were resolved at the end of the legislature. The particular amendments that were passed that are relevant here did impact Section 53.2 of the Iowa Code and some particular subsections therein. For just purposes of reference, Chapter 53 in the Iowa Code deals with absentee voting, and Section 47 establishes the powers of election commissioners. The plaintiffs have taken great pains in this case to narrow the scope of focus to just the 2 amendments that really to focus the attention on the 2 amendments that occurred in House File 2643, and ask the court to accept as a given the new way of managing the Secretary of State's powers that was crafted in the change in House File 2486. These changes that occurred must be viewed in the broader context of the careful system that was established to safeguard the integrity of the election process. Unfortunately, when they are taken out piecemeal and looked at a little bit at a time, it's difficult to get the entire picture of where these fit in and how they change the responsibilities and the checks and balances that were put in place in order to ensure the integrity of our election system. 47.1, as I mentioned before, of the Iowa Code sets out the scope of responsibilities for the state election commissioner, who is the Secretary of State. Auditor Weipert is the county election commissioner, which the powers are designated in 47.2. Section 1 of the 47.1 regarding the state elections commissioner sets forth the scope of his responsibilities and describes a variety of items that he is responsible for, and concludes by indicating that all of these there are all these responsibilities, and that the state commissioner shall adopt rules pursuant to Chapter 17A to carry out this section. Chapter 17A deals with the omnibus administrative rules, procedures in the state of Iowa. Section 2, subsection 2 of 47.1, before the adoption of House File 2486 was a section that recognized that there were some situations where the Secretary of State would need to exercise some emergency powers. Certainly, when this statute was written, it contemplated the need to be prepared in the event that certain types of things would happen that might impede the ability for an election to happen in the manner that it typically does. And then finally, subsection 4 of that same statute, emergency powers could be used. It's very important to understand that 47.1 has to be read as a whole. Created a new supervisory power that it was unlike anything that I can find any example of in the Iowa government previously. And it placed the Secretary of State's powers to exercise his emergency powers in the event of an emergency under the control of the Legislative Council. This is something that had not previously occurred. There are two provisions there, one of which has to do with essentially a veto power, and a second one which essentially allows the Legislative Council, if they don't like the proposal brought forward to them by the Secretary of State, that they could simply craft any remedy that they want. This seems like it's far removed from the issue of whether or not an absentee ballot request has somebody's name on it or not when it's sent out. There really is a very important part of the context. Plaintiffs really want you to just say, hey, want the folks to be on the emergency directive. An emergency directive came out from the Secretary of State. It was approved by the Legislative Council. He didn't do what it said, and therefore he's in violation of the law. The emergency directive was not a statute itself, nor was it a rule, an administrative rule under the notion of administrative rulemaking. It was a creature that did not appear to have existed before these events. The problem with the plaintiffs relying solely on that emergency directive is that that emergency directive is based on authority that should not have been delegated. And that delegation of powers is a clear violation of the Constitution. Again, there were two provisions in there. The first of which says that the Secretary of State's decision to alter conduct of an election using the emergency powers must be approved by the Legislative Council. Now, having discussed earlier the fact that there is a section that establishes that the duty of the Secretary of State to create administrative rules that set forth the powers in situations in which they apply, there are administrative rules that exist that specifically designate the powers that can be exercised by the Secretary of State in the event of an emergency. Those were promulgated through the rulemaking process under 17A. That is a process that the legislature does have an opportunity to weigh in on during the creation of those rules and before they are finalized in their promulgation. Those rules still exist. There was no affirmative action by the legislature by the bicameral House and Senate to validate any one of those particular administrative rules. So to the effect, those rules guide the scope of the type of powers that the Secretary of State can exercise in an emergency. It's very important that the integrity of these rules be maintained, because an emergency is exactly the sort of situation where there is a tendency to throw out the traditional way of doing things to try to expedite things, but cooler heads prevailed at a time when those rules for how that could be administered were set out. Those rules are still in effect, and the problem with the amendment to 47.1 sub 2 is that it now says that if the Secretary of State wants to use his emergency powers, that he has to get the approval of the Legislative Council. That is now places a member of the legislative body in a position where they may not be able to exercise powers that are delegated to them under the administrative rules. And instead, an outside entity is coming in from the representing the legislature, but not actually the legislature, to intervene, present and approve their own election procedures, or their own emergency election procedures, with no limitations. This is a situation that not only creates a separation of powers issue, but it creates a separation of powers issue, but it also gives the Legislative Council the power to take an action that would completely overrule the administrative rules that are already in place regarding emergency powers, and that would be done by what is essentially a committee of the legislature, not the bicameral House and Senate vote. The reason that I referenced the court to the powers in Chapter 2.42 is that it gives an overview of how historically the Legislative Council has functioned. It has never ventured into this type of role where they are stepping in and overseeing the Secretary of State, which is clearly a legislative function. The list of types of responsibilities that come under there are definitely, really would be more appropriately, in most cases, described as ministerial and administrative issues for the House and Senate. The plaintiffs characterize it as doing the business of the legislature, but that should not be misunderstood to mean that the Legislative Council can act in some kind of emergency capacity to pass laws that otherwise would be required to be passed by the House and Senate under all the procedures and restrictions set out by the Constitution. Again, our brief describes that there are two constitutional challenges here. The separation of power issue arises out of Article 3, Section 1, which says that there shall be three separate departments: the executive, the legislative, and the judicial. And no person charged with the powers properly belonging to that department shall exercise any function of another party. Well, the members of the Legislative Council are persons who have some limited powers that are designated under 2.42, in regard to their legislative responsibilities. But all of a sudden, now they're being asked to weigh in and have the legislature created for them an independent role to supervise the Secretary of State. This is a dangerous maneuver, and one that could lead to very serious and unintended consequences. Unintended consequences. Although that second prong did not come into play in this situation, because the Secretary of State proposed an emergency directive and then asked the Legislative Council to approve it, the fact that the second power existed there does permeate and paint the entire process here. The Secretary of State and the members of the Legislative Council would all be would have in mind that if they didn't reach some kind of agreement, that the Legislative Council could then begin to craft their own emergency power remedies, and it would be unhinged from the administrative rules, and who knows where that could lead to. That is one of the particular dangers that have been created by this entire situation. To make things even more confusing, the Legislative Council was asked to approve a power on the part of the Secretary of State that he already had the authority to do independently of his emergency powers. Iowa Code Section 53.7 which is again the Absentee Ballot chapter, talks about the fact that generally government employees are not allowed to solicit or accept or seek applications for absentee ballot or requests for absentee ballots. However, that provision specifically states that this section does not apply to elected officials. Both the Secretary of State and Auditor Weipert are elected officials. The 53.7 creates the ability for both of them to operate in that sphere and to send out absentee ballot request forms. They each independently would have that power as elected officials. However, when this emergency directive went forward to the Legislative Council, it was presented that in order for the Secretary of State to be allowed to go down that road and send out absentee ballot requests to everyone in the state, that it would have to receive the approval of the Legislative Council. Defendant argues that that simply is not an accurate description of the law, but it was the situation that was presented to the Legislative Council. Again, the Legislative Council is comprised of members of the legislature who do not specialize in election law. Unlike the Secretary of State, they do not have a necessity to be familiar with the administrative rules that guide what can and cannot be done in an emergency and guide the scope of what would happen in an emergency. The result of that, this whole series of events that never should have happened, was the emergency directive that ordered that first stated that the Secretary of State would send out the official absentee ballot request form throughout the state to all registered voters, and that county auditors were to only send out that particular official form that was designated by the Secretary of State. And that is the emergency directive that we are talking about today.
I don't want to break your train of thought, but you started this piece of your argument saying you had two. You started this segment of your argument talking about two separate constitutional challenges. You listed one, the Article 3, Section 1, separation of powers. What's the second one?
Yes, the second, constitutional challenge comes under Article 3, Section 30, which says, designates that in order to nullify a particular administrative, that the legislature has the power to nullify an administrative rule, but they must do so by bicameral action of the legislature. By providing to both of these provisions invoke that potential problem, because if the emergency powers if there was an attempt to exercise emergency powers that were outside of or not complying with the administrative rules in this area, and the Legislative Council approved that, then they may be nullifying existing administrative rules. And certainly, if they were to just to go forward and recommend their own procedures, and there's no reference here that it would have to be limited to the scope of the powers designated to the Secretary of State, that would be a clear violation. So both of those provisions in the Constitution should restrict this action, and it appears that both of those were ignored or not considered when this was hastily added. I again point to the fact that there was not an effort to amend the powers and duties in Section 2.42 to discuss this issue at all. And if there had been such a move, it may have been more apparent to people that this was a situation that invoked a problem of a constitutional authority, a challenge to the Constitution. If there was a desire to create to create new powers regarding the legislature's ability to nullify administrative rules, then that should have been something that would have been done through, that's something that would have had to been done explicitly through the bicameral action of the legislature. So now we have this unfortunately, we have this situation that has been put in place. However, it's important also here to keep in mind the administrative rules that already exist. I discussed those in my brief, but it is very important that the court look to those administrative rules to see what the plan was and what was already established in terms of what could be done. Under 721.21.1, there is an extensive description of what qualifies as an emergency disaster. It's not just the Secretary of State saying, I think this is an emergency, or I think this is a disaster. We included some argument in here that it's not entirely clear. In fact, I think there is some question as to whether or not specifically the COVID public health disaster falls within that express definition. At the end of the day, we expect that it could be determined that a public health disaster could come within the application of these administrative rules. But I point that out also just to draw the court's attention to the fact that it isn't a matter of just somebody saying something's an emergency. There are very specific criteria that have to be met. There's also a provision that says that in the event that a county commissioner believes that there is a disaster or an emergency or a disaster that qualifies as an emergency in their county, there's to give the state commissioner notice of that. And once the state commissioner gets notice of that, they'll consult and develop a plan as to how to proceed. This is not a situation where the Secretary of State has just unilaterally comes in and makes the decision. There's actually a request that comes up from the underlying county. There are also some general provisions that say, in the event that it's triggered by an emergency, a disaster that qualifies as an emergency, those powers are limited to the enumerated enumerated items that are contained within administrative rules. There are also, though, even more specific limitations that are placed in situations where there are federal elections. Those limitations, as I described in my brief, have to do with various different issues such as scheduling, or particularly to relocation of polling places, modification of voting, reduction of the number of precincts, election officials at a precinct, and other modifications of prescribed election procedures which will enable it to be conducted on the date and during the hours required by law. The methods of the emergency directive here does not fall within those categories of emergency powers. The absentee ballot request being sent out by the Secretary of State was already authorized, and then the restriction on county auditors is not one of the enumerated powers under the administrative code. So when the Legislative Council went ahead and validated that, they did not have authority to do that, because even under the way that code section was amended, it does state that if they want to alter any conduct for an election using the state commissioner's decision to alter any conduct for an election using the emergency powers must be approved by the Legislative Council. They left intact the portion that said that those administrative rules are still in effect, and they still are in effect, and there was no authority for them to go down that road. I also would, somebody might argue that the modification of the method of voting may cover the order to the county auditors, but the term, the method of voting is used as the caption for Chapter 49 of the code. That contains 128 subsections, and only one of them has an even mention of the absentee ballot process, and that is section 49.72, which states that prior to when a polling place opens, that a list of all the persons who would be in that precinct who have requested absentee ballots shall be provided at that precinct. It has nothing to do whatsoever. All of the other provisions that are in there in Chapter 49 regarding the methods of voting have nothing to do whatsoever with absentee ballot requests. And it is not reasonable to interpret that section in that manner. Again, returning to the statutory powers set forth in 47.1, as I mentioned earlier, the statutory provision there in Section 1 sets forth a variety of different responsibilities, which includes prescribing uniform election practices and procedures. But that is followed by, and shall adopt rules pursuant to Chapter 17A to carry out this section. If indeed the Secretary of State was going to move forward in order to prescribe uniform election practices and procedures, the method for doing so would need to be under the process of the administrative rules. He would need to have adopted rules pursuant to Chapter 17A. There are some provisions for emergency rulemaking. There was some time from the time when this issue was folks were made aware of it until a decision needed to be made, but that process of 17A rulemaking was not followed, and the decision to move forward to establish those uniform election practices should not have been authorized, and certainly should not have been authorized under the emergency rulemaking provision. As mentioned before, 53.7 not only gives the power to the Secretary of State to issue or to send out absentee ballot requests, but it also provides that power to the auditor. And the language about supervisory powers is not reasonably read to mean supervisor in the sense of a boss and a subordinate in a business context. Both of them are elected officials that are, and there are no powers for the Secretary of State to hire, fire, or direct the individual everyday activities of the auditor. Now turning to the amendments that were added to Chapter 53.2. The plaintiffs want to specifically focus on the amendments that were approved in June of 2020 and the requirements of those. However, if 53.2 is read as a whole, it does not contain any express prohibition for the auditor to send out pre-populated ballots. It's clear under 53.22 that the Secretary of State has the power to prescribe a form that would be used for the purposes of an absentee ballot request. However, there is express language in the statute that goes on in 53.2 to say, if a registered voter submits an application on a sheet of paper, and then it gives the size limitation, that includes all of the information required, the prescribed form is not required. That provision was not amended and continues to remain in the statute. And Auditor Weipert was reasonable to view that portion of the statute to indicate that although a prescribed form existed, that a form that was not that prescribed form that still that included all the information would be acceptable, and that a prescribed form would not be required. One of the other changes one of the other issues that was brought up by the plaintiffs is that now 53.24A says that to request an absentee ballot, a registered voter shall provide. And note that although it provides a list of information that shall be provided, the statute does not say that it shall be personally provided. It does not give any further qualification of that. In other places in the Iowa Code where the term shall provide is used as terminology, it is really used in a general sense that the information is made available. It does not require that it be personally provided. And that language was not explicitly included in here. Although it is true that the new amendments did include a limitation on the auditor's ability to use the iVoter system to correct a form that was submitted to his office, that provision should be limited to what it says, that the iVoter system cannot be used to correct something that was already sent in. If a person fills out the form and it's unclear what they meant, there's a process that needs to be followed. Our Auditor Weipert is now under that restriction, and regardless of whether somebody returns an absentee ballot request form that was sent out by the auditor's office or any of the other forms that are out there, and they do receive a number of forms that are submitted to their office in various different formats. As long as it contains the information and a signature indicating that it's provided by the registered voter, then that form, there is authority for that form to be accepted.
We stop there. On something that I want to talk about in the context of some things you raised. So 53.2 as amended effective July 1st, you're not challenging anything about the constitutionality of that statute or the amendments, is that correct?
Well, Your Honor, I believe there are some applications of, there's our possible interpretations of 53.2 that could lead to the statute being found. They're unconstitutional, but we're not expressly challenging it on its face as being unconstitutional.
But my question is simple. Your constitutional challenges have to do with 47.1 and then the rulemaking process, essentially, correct?
And then also by implication, constitutional challenge involving the home rule.
Okay.
Because
right. We haven't got the home rule
right,
yet. Right.
But that would be a third issue of constitutionality.
Right. Specifically, you're not challenging the constitutionality of the change where the legislature says if we've got missing or inaccurate information on an absentee ballot, you have to go get that from the voter. Is that correct?
At this time, we are not bringing a challenge. We are aware that there is a pending challenge to the constitutionality of that. And I would submit to the court that concerns over the application of that statute for several different reasons were part of the motivation for Auditor Weipert to move forward in the manner that he did.
We're going to talk about that too and the timing of that, but you just not at this time. So part of your resistance of this, you're not challenging what 53.2 sub 4 says now. And
we are not independently raising a constitutional challenge to 53.2.
Right. And obviously, no surprise, because I did the Lynn County case. One of the things that struck me in that case, and it's similar here, is if the legislature specifically forbids the auditor or the elections commissioner from going out and partially completing an absentee ballot request, why would the legislature specifically come out and make a, but on the flip side say, but if you want to fill those gaps ahead of time, go ahead. That logically doesn't make sense to me. So what am I missing?
Well, Your Honor, there wouldn't be any gaps ahead of time in this situation. And part of the rationale for that is the information that has been contained in the affidavit that the iVoter system in general in Iowa is extremely robust in terms of its accuracy, and that.
But that's irrelevant if the legislature says you can't use that system to fill in gaps, no matter how great it is or how accurate it is. If the legislature says don't go there. Once you get the ballot, how can you go there and create the ballot?
Well, the decision to add that language still has to be read in concert with the rest of the statute. And the rest of the statute still provides that a form that's not the prescribed form that has all the information that's submitted by the registered voter, will be acceptable, and that it does not have to be on that prescribed form.
We're not talking form, though. We're talking substance. We're talking substance of the application. The substance of the application includes name, it includes birth date, it includes either your voter PIN or your driver's license number. Right, doesn't form just mean, here's the format we want you to fill out, put your name here, put your birth date here? Are you saying that format is the same as content?
Well, the provision that allows an alternative form to be submitted does not prescribe how that information is gotten on there. Again, there's also the provision that talks about that the information has to be provided by a voter, but it does not say it has to be personally provided. And in this situation where Auditor Weipert was confronted with the problems of, particularly in a large county, confronted with the tricky issues that would be involved in processing so many requests in a short period of time, that by using the validated and accurate information that was already in the system and sending it to a specific location that would be linked to that voter, that person would have an opportunity to advise of any corrections or any changes in the information that needed to be provided. They are no longer then in a position of having to second guess what the applicant meant when they turned in their application.
So are you saying that was an anticipatory gap-filling measure?
I would not describe it as an anticipatory gap-filling measure. I would describe it as an option that, given the statutory express authorities that are set forth in the statute as a whole, that it was reasonable for Auditor Weipert to act, given the guarantees that he had regarding the integrity of that system, that was a reasonable way to proceed in order to be able to allow all voters to have an opportunity to vote safely and securely.
So Mr. Weipert, doing his job, and certainly don't have an issue with that, sees this change and says, well, I don't want to have to deal with that on the back side, so I'm going to fix it on the front side. Is that what you're telling me?
What I'm telling you is...
All right, well, I won't make you commit to that. But then let me ask you this. If that really was the trigger, then why not challenge this statute on July 1st when it became effective? Why not challenge the Legislative Council's directive on July 17th? I think these applications didn't go out to what, August 10th, is that correct?
Yes, I understand Your Honor's question, and then this probably does venture over into the territory raised in supplementary resistance, but the law is fairly clear that a preemptory counsel, sort of an assertive, an affirmative action to challenge the constitutionality of that statute could not be brought by the auditor himself in order to stop this from moving forward. And although we still maintain that there is a basis for raising that constitutional challenge in the posture of this case, that we believe that it would have been very difficult in order to be able to move forward, given the case law in Iowa in regard to affirmative actions to declare statutes unconstitutional.
Didn't the
To what we thought would be a good